Hey, old folks. Remember Dever and her false memory? And remember a few days ago, Commissioner Cox, well, made some interesting statements. When interviewed from another matter, somebody was wise enough to ask him, "What about Dever? Your meeting?" And he went, "Yeah, let's just say, I really, really would like to see the result of that drug test because how he acted, not normal." At the same time, apparently, Alan Jackson wrote a letter to Commissioner Cox about Dever and her false memory. Let's go through it. Dun dun dun. Worksman Jackson and Quinn, July 10th, 2025, regarding Brady Giglio disclosure, Officer Kelly Dever. Dear Commissioner Cox, pursuant to the obligations established under Brady versus Maryland and Giglio versus United States, this letter serves formal notice that a member of your department, Officer Kelly Dever, must be included in the Brady database. Now, what is the Brady database? Well, that is a database of information that is handed over to defense attorneys. They can go look through it. Who is this officer? What have they done? Dun, 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 all of that things. And in there should be Officer Dever. Because somebody who makes us who makes up false memories, yeah, that's not a trustworthy person. More or less. It's information that should be handed over to the defense, just in case she is about to testify. Then they can impeach her with, "Hey, you make up false memories. How can we be sure what you are claiming now is an actual memory and not something you just made up?" So that is what it is. The grounds for a mandatory inclusion in the database are outlined below. As you are no doubt aware, Officer Dever was a witness called by the defense in the matter of Commonwealth versus Karen Reed, a high-profile murder case that was tried for the second time in Norfolk Superior Court in April of 2025. The case received extensive national and international media coverage. Hello, I'm international media coverage. Officer Dever's involvement in the case stemmed from her interview with agents from the United States Federal Bureau of Investigation, FBI, during which interview Officer Dever explained to the agents in detail her observations of former Canton Police Chief Kenneth Berkowitz and Special Agent Brian Higgins of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Well, in Higgins' case, it's just tobacco, firearms, and explosives because the alcohol goes down his throat. In the Sallyport garage of the Canton Police Department, she described seeing both individuals enter the Sallyport garage of the Canton Police Department where the SUV in question was located on January 29th, 2022. Officer Dever described in indelible detail that she witnessed Chief Berkowitz and Mr. Higgins go into the Sallyport and stay there for a quote-unquote wildly long time, and that she thought it was weird that a witness on the case, Higgins, would have access to a seminal piece of evidence, the SUV, in the investigation. During her lengthy interview with federal agents, she articulated her observations in considerable detail, including specifics about the monitors she was viewing at the dispatch desk. She described at length her observations of the two men entering the Sallyport with the SUV. Officer Dever claimed no issues with her memory, and she was clear with the agents that she made her observations in the afternoon or early evening of January 29th, 2022, at the end of a shift after the SUV has been secured in the Sallyport. Subsequent thereto, the federal authorities provided a report of their interview with Officer Dever both to the prosecution and to the defense in the Reed matter. In or about April 2025, the defense issued a subpoena for Officer Dever to testify in the murder trial. And on June 2nd, 2025, she was subsequently called and sworn to testify before the jury. During her testimony under oath, Officer Dever changed her statement, claiming not that she did not make the statement to the federal agents, but her observations of Chief Berkowitz and Mr. Higgins was a quote-unquote false memory. She maintained under oath and throughout her testimony that the events she described to the federal agents never happened, that the memory she was recounting was false, and that the events she described did not actually occur. It is clear, therefore, that one of two things are true. Either Officer Dever lied about having a false memory, or she actually suffers from a condition that subjects her to false memories. In either case, her credibility and reliability as law enforcement officer are irreparably compromised. If she lied under oath, Officer Dever is guilty of perjury. If she truly suffers from false memories, she is unfit to serve as a police officer. Her reports, statements, and testimony can no longer be presumed accurate, and any case, current or prior, involving Officer Dever must be reviewed accordingly. Oh yeah, remember when she said on the stand, "Oh, she testified in about a dozen cases," and in my opinion, those needs to be reopened. It really has to, because if her testimony is that she saw somebody do something, how do we know? She is either prone to lie under oath or she has a false memory. So, regardless of her testimony, it has to be reviewed again. Any case she's ever been involved with. Where was These are here. These circumstances bear directly on Officer Dever's credibility and represent impeachment evidence pursuant to Brady and Giglio. Given these facts, it is clear that it is incumbent upon your department to immediately include Officer Kelly Dever in the Brady database, and all information surrounding her claimed false memories must be disclosed to the defense in every case in which she is a witness or potential witness. As you are aware, both the prosecution and law enforcement share a constitutional obligation pursuant to the Due Process Clause of the 14th Amendment to affirmatively disclose exculpatory and impeachment information for the defense in every case. The Supreme Court has mandated that, quote, when the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the Brady rule. Failure to disclose Officer Dever's intentionally false testimony and or her false memory condition would be a constitutional violation, subjecting both the prosecution and the Boston Police Department to severe sanctions, the least of which is the dismissal of every case she touches. If it is determined that your department was on notice, which this letter formally provides, and the department does nothing to include Officer Dever in the Brady list, and thereafter provide to the defense the exculpatory and impeachment material in its possession, the sanctions can and will be far more extreme. Wow. Yeah, and then it's signed with. Then it's signed with Alan Jackson. Da, 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 da. So yeah, again, I've been through Officer Dever and my opinions on her. I'll post a link up here somewhere. I think people generally don't understand the severity of this. It's almost gallows humor when it comes to Officer Dever. But this is serious because her testimony has put people in prison. People who actually might be innocent, who actually sat there on the defense table wondering, who is she and why is she making shit up about me? That is a strong possibility. And after what Officer or Commissioner Cox did, I think he knows. He just doesn't know how to get out of it. And for a commissioner, there's actually only one way to get out of it. Well, two ways. Either she goes, or you go, or both go. Three options. She goes, you both fuck off. All right, that was Alan Jackson's letter. Thanks for listening in. You all have a good one. Do all the YouTube things, and yeah, I'll see you in the next stream or video. Have a good one. Bye bye.